Hi, this is Kim Cruz with my presentation over tort law. What is tort law? It's a civil wrong for which a remedy may be obtained, usually in the form of damages. Tort claims usually involve state law and are based on the idea that individuals are liable for the consequences of their conduct. In the school context, teachers are liable for acts that may cause injury to a student while under the teacher's supervision. There are two major categories of torts typically observed within the education-related cases: intentional torts and negligence. In the case Johnson Johnson versus School District of Millard, a class of first graders was playing London Bridge for the first time in music class. A student was caught in the bridge, and the students let go, flinging the student into a bookcase. He suffered blurred vision, a cut needing 50 stitches, and had continued headaches. The teacher was at the blackboard when the accident occurred, not seeing the accident. The judgment was in favor of the parent, finding the school negligent. The parent was awarded $21,226.10 in damages. The court felt like the teacher was not monitoring and should have monitored better as well, because it was the first time these students had played this, and it was that teacher's responsibility to ensure the safety of the student. Reactive measures in my district, the protocol would be an incident report would be filed, and administration would investigate the causes of the accident, who witnessed it, what happened before, what was the teacher doing, what were the other students doing. As an administrator, I would implement yearly reminders and trainings on active monitoring and what it looks like. Teachers get used to doing things a certain way, and sometimes we need those gentle reminders to stay on top of things. And bringing up court cases like this one, just as a reminder of what the consequences can be for not monitoring students well enough. Student safety is our ethical obligation. To not monitor, to not ensure their safety, violates ethical codes. And again, teachers just need to be reminded of these things. In Juadry versus Rapids School Board, parents of an intellectually impaired female student sued the school district for negligence after their daughter was sexually assaulted by another intellectually impaired male student. The supervising teacher had left the students to go for a smoke break. She was with two male students when she left. The court stated that the schools offering training for mentally, emotionally, or socially handicapped young people have a duty to use reasonable care to protect their students from harm. The teacher's knowledge of the need for constant supervision over the boy set a standard of care. When this teacher realized that the students were missing, she immediately rushed back to the commons area where this occurred to find one kneeling over the young lady. The parents were awarded $16,000 in damages. Reactive measures from my district, to an assault, my district would notify parents and call the school resource officer to make a report to the police. A meeting would be called with special ed staff to review the students' IEPs, all the students that were involved, and to determine if they had been followed or if our IEPs were out of compliance in any way. As an administrator, I would periodically check students' IEPs and staff schedules to ensure that students' needs are being met and to be proactive in making sure students are supervised as needed. I'm at a little bit of an advantage because I know how to access the IEPs. I know how they should be written. I think it's important for administrators to inform themselves, ask questions, and know what students' IEPs say so that they can make sure that their staff are following those IEPs. It's unethical to leave students with disabilities that need constant supervision alone. There needs to be a system of checks and balances in place to ensure that students' needs are met. In Mitchell versus Cedar Rapids Community School District, a 14-year-old female special education student with an IQ of 67 skipped her last period or class with another special education student who was 19. The female's mother was not notified per school policy. There was an electronic system of notifying parents of skipping classes after school was out. So it was an electronic phone call or a text message, and those didn't go out until after the end of the school day. This young lady was under constant supervision at home and had called home and asked to go to a friend's house after school, and then skipped her last period of the day. The male and female student went to another student's house where the female student was raped. The female reported the incident to her mother a year later. The school was sued and found liable for $500,000 for not responding adequately to her unexcused absence. The school district's failure to respond adequately to a special education student's unexcused absence during the school day made it liable for her assault outside of school grounds and after the school day had concluded. So this case was argued that it was outside the scope of the school because it happened off school grounds and it occurred after the school day, but because the staff did not take appropriate measures to notify parents that this young lady had skipped her last class, the courts found the district liable. Reactive measures. In reaction to an assault of this nature, my district would notify the police as well as the school attorney. The school would do an internal investigation into what the student's IEP required and if there was a breach in the school's responsibility. As an administrator, I would work with gen ed and special ed staff to set up measures to ensure high-need students remained within the building and made it to each of their subjects. Simple communication between staff when a student is absent could have helped in this situation. If it's just set up as protocol when high needs students are absent, that there's an email that goes out, the student's absent to all staff, then they would not expect the student in class. We want to promote independence, but yet keep our students safe. Therefore, if the student was absent, but that communication had not been done, gen ed staff can take responsibility and say, we have to find her, or we have to find him, where are they? And then administration can step in and help with the situation. All staff ethically bear the burden of keeping students with special needs safe. Making monitoring these students an entire staff responsibility is just one part of remaining ethical in this situation. Rollins versus Concordia Parish School Board. The district was found liable for neglect when a 9-year-old female broke her leg while on a merry-go-round. There was a substitute teacher monitoring boys playing basketball while the girls were on the merry-go-round. A total of 40 students were outside to be monitored by one teacher. The sub noticed the girls going too fast on the merry-go-round and told them to slow down and get off. The sub was then called over to the boys because there was an argument over a basketball. While the sub had gone to address the boys, the girl fell and broke her leg. The district was found negligent because the sub abandoned what she had determined dangerous. There was another teacher available to help monitor these students, but was given a free period. The accident was reasonably foreseeable because the girls had been ordered off the merry-go-round. The girl was awarded $10,000, but it was lessened because it was determined that the girl bore 50% of the liability in her accident. It was lessened to $5,000. In reaction to an accident of this nature, my district would require an accident report be completed, and the administration would take statements from those who witnessed the accident. Upon being sued, the school attorney would be notified, and statements would be turned over to the attorney. Having trainings for substitute teachers, as well as gen ed teachers, all teachers, as to the expectations for monitoring students while on the playground is very important. All teachers need yearly trainings on what is expected for recess and playground duty. Following up as an administrator to make sure those expectations are met is important to ensure compliance. As an administrator, you can set expectations and policies, but if you don't follow up and make sure they're being put into place, then the administrator is being negligent. They need to stay on top of things. Ethically, teachers have an ethical duty to monitor students. Administrators have a duty to make sure that policies and procedures are followed. Anchorage, Alaska, Rogers Park Elementary School. This case was in 2014 in Anchorage, Alaska, case involving a kindergarten student at Rogers Park Elementary. The student was dismissed from his kindergarten teacher to his mother. They were within eyesight of each other. The student ran for his mother and fell. Upon falling, a limb penetrated his eye socket, entering his brain and causing brain damage. The mother sued the school for negligence in allowing the tree stump to be in the area where small children frequently walk. The school was found negligent, and the mother was awarded $4.5 million with an additional $180,000 for pain and suffering. Reactive measures. Of course, an accident report would be completed, and the administration would take statements from those who witnessed the accident. As an administrator of a building, I think sometimes we focus on the inside, and we need to look to the outside. Keeping a school ground safe, free from debris, is very important. And these sorts of checks need to be done periodically as seasons change, as ice forms. Do you have an area outside your building that's continually having ice build up, and what can you do to fix it and remedy that problem? We need to think of the whole building inside and out when it comes to liability issues. And ethically, schools have an ethical obligation to be safe schools. Policies need to be in place to make sure all are safe when at school. I think in the end, diligence is just the word that comes to mind. Administrators need to stay diligent to prevent liability and neglect by staff. Having trainings and providing information is one step in helping to prevent legal issues for staff. Thank you for your time.